The Judiciary Committee will come to order, and the clerk will call the roll.
Mr. Smith?
Present.
Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Pence? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Griffin? Mr. Marino? Mr. Gowdy? Mr. Ross? Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Conyers? Mr. Berman? Mr. Nadler? Mr. Scott? Mr. Watt? Ms. Lofgren? Ms. Jackson-Lee? Ms. Waters? Mr. Cohen? Mr. Johnson? Mr. Pierluisi? Mr. Quigley? Ms. Chu? Mr. Deutsch? Ms. Sanchez? Mr. Polis?
The gentleman from Texas, Mr. Poe. Gentleman from North Carolina, Mr. Watt. Gentlewoman from California.
Ms. Waters?
we have the clerk will report.
Mr. Chairman, 13 members responded present.
We have a working quorum, so we will resume our markup and consider amendments. Before I recognize the gentleman from Virginia, Mr. Goodlatte, for an amendment, I want to alert members to these changes. The revised text for amendments 28, 39, 42, 54, 55, 58, and 59 were emailed to committee members' offices this morning. Without objection, those revised amendments will be considered in the place of the original filed amendments as we proceed through the roster today. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Goodlatte.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, this is a technical amendment to clarify the intent of the manager's amendment that the safe harbor contained in Section 104 of the bill does not trump protections elsewhere in the bill that make clear that Internet service providers are not required to block subdomains. This is a technical amendment that corrects an ambiguity in the manager's amendment, and I urge the members of the committee to support this amendment.
Okay. Will the gentleman yield?
Yes.
I agree with the gentleman. I support the amendment as well. I urge my colleagues to support it. Are there other members who wish to be heard on this amendment? If not,
Mr. Chairman, I move strike the last
gentlewoman
word.
from California, Ms. Lofgren.
I oppose this amendment, and I don't believe it is simply a technical amendment. This amendment would protect Internet service providers who are too cheap to block only a portion of a site, and instead who would choose to block a whole site using DNS blocking, even when a court order only specifies a portion as infringing. To endorse this activity on the part of DNS blocking of entire sites, even where there is a more specific order that relates only to the infringing sites, could have the impact of adversely impacting legitimate speech. It sometimes, and we've seen this in the past, the misdeeds are just on one subdomain or even one page. And if you block the entire site, you will be have the effect, quite likely, of blocking non-infringing speech. This amendment, I think, is a further endorsement of the DNS blocking scheme, which has been criticized as harming cybersecurity. We had a substantial discussion of that yesterday, and likely will have additional discussions as well. The existing 104A and the manager's amendment states that intermediaries are not required to punish a whole site if a court order only specifies that a portion is infringing. And this further amendment to eliminate the only punish the bad person concept is really not the right way to go. In fact, I had been looking and may yet provide a proposal that whereas it is permissive not to block an entire site, we would be required not to block an entire site. This goes in the completely wrong direction. The safe harbor states that the DNS blocking fully discharges the obligation when you prevent access to subscribers to the limited site. And to do as Mr. Goodlatte suggests would trump the section. It would bless overblocking by ISPs. I don't know whether a court would block it as violative of the First Amendment. I have not had the opportunity, and hope maybe I will today, to review the advice that Mr. Sensenbrenner referenced yesterday from Professor Tribe. I'd love to do that, but I think this is it's certainly wrong, perhaps unconstitutional, and we should vigorously oppose it. And with that, I would yield to Mr. Paulus.
Thank you, Ms. Lofgren.
Thank you. I just want to be clear, and I'll be taking out my own time on this as well. But I don't, and I'll engage Mr. Goodlatte for this. if the gentleman from Virginia has a moment. I mean, this appears to be, I think this was presented as a technical amendment. Would the gentleman agree that this is an amendment that does change the implications of the bill and should be debated on its merits rather than as a technical correction?
Well, the gentleman and the gentlewoman may not like the underlying principle in the bill, but it's a technical amendment in that it conforms the manager's amendment to other language elsewhere in the bill, and for that reason, you know, you're welcome to debate that principle elsewhere in the bill or offer an amendment to the underlying principle, which you've already done. But the fact of the matter is, this makes the amendment conform to other language already in the bill. And as the gentlewoman noted, nothing can be done here without a court order. So if a court is going to require somebody to overblock, then all of these issues will come up in that legal.
But reclaiming my time, I think the gentleman's incorrect. The amendment, by having Section 102C2A override Section 104A, you would require ISPs to receive a court order for a foreign infringing site to prevent access by its subscribers to the site. The safe harbor is actually being changed. This is not just a technical amendment. This is something that provides a substantive change that is violative, probably, of the First Amendment, and I'm sure that the gentleman offers it in good faith as a technical amendment. It's not merely a technical amendment, and it should be opposed. And in fact, we should be going in the exact other direction. If members are sincere, that they are concerned about infringement, then and we want to narrowly tailor our actions towards infringing material, the last thing you want to do is to overblock so that you're shutting down entire sites instead of just infringing material. That's what this amendment would do, and it should be opposed.
The gentleman's time has expired. Are there other members who seek recognition? The gentlewoman from California, Ms. Waters, is recognized.
Thank you very much, Mr. Chairman. I'm paying special attention to this because this is one of the areas of concern that was brought to my attention during the period of time we were attempting to do our research. We had internet users who talked about the fact that if a portion of an internet site was infringing, that the underlying bill was attempting to block the entire site. But this seems to straighten that out, and I want to know from those who oppose it if this is not a way to correct any action that would block out an entire site rather than just that portion which is infringing, and isn't this a technical improvement? That's what the wording says. In any case in which only a specifically identified portion of an internet site is identified by the court, as an infringing site or as an internet site dedicated to theft of U.S. property and made subject to an order under paragraph, and then it goes into the sections 102B, 103B, the relief granted under such paragraph and the obligations of any entity served with a copy of an order under section 102C or 103 shall be confined to that specified portion so identified and made subject to the order. What's wrong with this? I think that this specificity clarifies any ambiguities that may be in the underlying bill. And I just think this is an improvement. And I just don't understand the opposition.
Would the gentlelady yield?
Yes, I will yield to the gentlelady.
Here is, I think, what it does. If you look at the second page of the amendment, line 6, subparagraph A of section 102C2 essentially says do what you want to block. And going on further to line 9, 102C2, you're going to be deemed to comply with any court order and entitled to all defense and limitations on liability, regardless of whether the order identifies or specifies only a portion. So the effect of this amendment is actually to do what you don't want, which is to say if you overblock, even though a court has identified a small portion, you're entitled to immunity, and it will basically give a free ride to service providers who are too cheap to actually go down to the
reclaiming my time.
I thank the gentlelady for allowing me to explain.
there is nothing in the language that you have described that would override the first page of this amendment. Shall be deemed to comply with such court order and entitled to the defenses and limitations. The court order specifies the blocking or the taking down or what have you, specifies. So how do you spread this to deem that they would be in compliance if they did anything other than relate its actions to the specified portion
Will the gentlelady
of
yield?
The Internet?
Will the gentlelady yield?
The gentlelady will yield to Mr. Goodlett.
And she is quite right, but I would like to add to those who are criticizing this provision, the underlying bill is very clear when it says in Section 2, Savings and Severable Clauses, number 1, First Amendment, nothing in this act shall be construed to impose a prior restraint on free speech or the press protected under the First Amendment to the Constitution, and this amendment leaves it to a court to decide whether or not blocking should be ordered, and I think it makes it consistent with other language in the underlying text of the bill. It's a clarification that makes the bill consistent. You can say you don't like the bill, but you can't say this isn't a technical amendment that corrects the bill.
Gentleman's time has expired. Are there others who seek recognition? The gentleman from Colorado, Mr. Polis.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Well, you know, again, I just, in brief response to the gentleman from Virginia, I mean, he cited that this has to comply with the Constitution. Any bill does, but that's not an excuse to pass statutes that are bad policy, and I believe this is bad policy. Whether it's invalidated by a court later on or not is not for us to say. In response to the gentlelady from California as well, I wanted to point to the areas of this amendment that we're talking about here. It's the preservation of limitation language that is at issue here, lines 6 through 14, where effectively it says that there is a safe harbor that is not affected if, regardless of whether the order identifies or specifies only a portion of an Internet site to be taken down. And in fact, the website is deemed to comply with a court order and entitled to these limitations on liabilities that are provided here, again, regardless of whether such order identifies or specifies only a portion of an Internet site.
Would the gentleman yield?
I'll be happy to yield generally from
If
California.
I could, I think it might help to think about this conceptually in this way. It doesn't require an ISP to overblock, but if an ISP overblocks, the lines just quoted by my colleague from Colorado give you a complete defense of liability. And so the problem is that if somebody overblocks and it's cheaper to do it, just take the whole thing down. This is a complete immunity for doing so. This is going to lead to problems, and I thank the gentleman for yielding on that.
It'll lead to the path of least resistance, which is rather than take down the offending content, take down the entire site. And most large sites have user-generated content as most of the site, whether you're talking about something akin to a YouTube or a Reddit or whatever it is. Most of the information on those users, and when you have millions upon millions of pieces of user-generated content, it's always possible that, and likely that some might be infringing. The way the DMCA works domestically is the infringing content is taken down. When somebody posts themselves singing a copyrighted song to YouTube, YouTube doesn't go down. The ISP doesn't take YouTube down. Their DNS is not disabled. They're given a notice and the song's taken down. And yes, there's remedies if they refuse to comply with that, as there should be. Here we have a very, very different approach for foreign websites than we have for domestic websites. And in the global economy, that's a very bad precedence. Effectively, you're saying here, you know what? You get the same protection and safe harbor if you take down the whole site and disable it, or you just take down the offending content that is in violation of a copyright. And as the gentlelady from California pointed out, the easier thing for an ISP to do is simply to disable the whole site. Now that leads to, again, the censorship of the Internet, the bifurcation of the Internet, the balkanization of the Internet, because you might have sites with tens of millions of pieces of user-generated content most of which is entirely legal and not infringing, but because of the actions of some, and again, those actions are, if there is infringing content, it needs to be taken down. But that's a different question as to whether the entire site should be disabled. So any type of safe harbor in this area has to be narrowly tailored with regard to the offending content and not apply to the website at large, as it's expanded to do under the preservation of limitations section of this amendment. I'll yield to the gentleman from Virginia.
Well, I thank the gentleman for yielding. First of all, the bill makes it clear that a court can only order the takedown of a full site.
Yeah, reclaiming my time. We're not talking about what the court is ordering. Yes, the court says take down the offending content. Me to finish my point. Mr. Chair, we need to be in a request order. Look, we're not talking about what the court orders. The court orders they take down a specific component. You then tell the ISP, look, you get the same safe harbor if you
it's a remedies question.
It's a remedies question. It's not a question of what the court order entails, and it is technically easier for them just to say the whole site is off rather than say this posting by user XYZ and this posting by user Y.
The gentleman will yield.
I'll yield to the gentleman from Virginia.
The court can only order the takedown of a full site. So the court is not, because of the provision in the bill that says that you cannot infringe on one's free speech rights, they're going to rely on the other remedies in the bill. They're not going to rely on this remedy under those circumstances.
Requesting my time. We're not talking about the courts. We're talking about giving the incentive for private actors, ISPs, to censor in the name of reducing their liability.
Would the gentleman yield?
That's exactly what you're doing here.
Would the gentleman yield?
Be happy to yield.
The private actor cannot act unless the court orders them to do so.
Yeah, only the court order about a specific piece of content. The court order does not have to apply to the whole website.
Has expired.
The question. Could I ask for unanimous consent for an additional 30 seconds that I might be yielded?
Without objection,
Be happy to
the
yield
gentleman from Colorado is recognized for an additional 30 seconds.
Here's the scenario. You have eBay Germany, and there's one eBay vendor that's selling bogus purses. The order should come to the portion of the site, but if you take down all of eBay Germany, the ISP is going to have complete immunity under this amendment. And I thank the gentleman for yielding. That's the problem. I don't have the.
I believe my time's expired.
Mr. Chairman.
The gentleman's time has expired. Now the question is on the amendment. All in favor of the Goodlatte amendment? All in favor say aye.
Aye.
Opposed, no.
No.
Opinion Chair, the noes have it.
I'd ask for a recorded vote.
Recorded vote has been requested. The clerk will call the roll.
Mr. Smith?
Aye.
Mr. Smith votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Coble? Mr. Gallagly? Mr. Gallagly votes aye. Mr. Goodlatte? Mr. Goodlatte votes aye. Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes no. Mr. Pence? Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Griffin votes aye. Mr. Marino? Mr. Marino votes aye. Mr. Gowdy? Mr. Ross? Mr. Ross votes aye. Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Amade votes yes. Mr. Conyers? Mr. Conyers votes aye. Mr. Berman? Mr. Berman votes aye. Mr. Nadler? Mr. Scott? Mr. Scott votes aye. Mr. Watt? Mr. Watt votes aye. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Waters? Ms. Waters votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Mr. Deutsch? Mr. Deutsch votes aye. Ms. Sanchez? Ms. Sanchez votes aye. Mr. Polis?
No.
Mr. Polis votes no.
The gentleman from Ohio.
Yes. Mr. Jordan votes yes.
Gentleman from New York.
Mr. Nadler votes no.
Are there other members who wish to be recorded on the vote? The clerk will report.
Mr. Chairman, 22 members voted aye, 5 members voted nay.
The majority having voted in favor of the amendment is agreed to. We will now return to an amendment that was postponed yesterday, and the gentleman from Wisconsin, Mr. Sensenbrenner, is recognized to offer that amendment.
Mr. Chairman, I have an amendment at the desk, which is number 18 on the roster, and it's Sensenbrenner 042.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Sensenbrenner of Wisconsin. Strike Section 103, page 20.
Without objection, the amendment will be considered as read, and the gentleman from Wisconsin is recognized to explain his amendment.
Mr. Chairman, this amendment is quite straightforward. It strikes the private right of action from this legislation altogether. And I would hope that we would consider the private right of action issue differently than we would consider this entire bill. I have made no bones since yesterday that I don't think this bill is the right way to go, but I think the private right of action, whether the bill passes or fails, should be stricken from the legislation, and here's why. The private right of action will simply give the trial bar in this nation the right to go after everybody who is covered by this bill, alleging that they're not doing what the bill calls for. And in effect, because the Justice Department is also given the right of a private right of action, it delegates law enforcement functions to individuals. And the Supreme Court has been very wary, absent an explicit private right of action, to imply a private right of action in other legislation. In Astra USA, Inc. versus Santa Clara County, California, Justice Ginsburg for the court reversed the Ninth Circuit in holding that the Public Health Service Act nor the pharmaceutical pricing agreement signed by Medicaid participants empowered health care facilities to sue drug companies for alleged overcharging. Only the HHS Secretary possesses law enforcement powers in such situations. Now, here what we're doing is we're giving a rights holder a private right of action to do what the Justice Department read law enforcement ought to be doing on their own. And this is a very, very dangerous precedent to set in this legislation, because if it is approved in this legislation, there will be requests to include private rights of action in practically every other bill relative to remedies that this committee will consider. If the rights holders are convinced that entities aren't meeting their obligations, they shouldn't be allowed to haul the entities into court in a law enforcement capacity. And this amendment stops that from happening. A private right of action allows trial lawyers to enforce the laws in lieu of the state. It's used on the state level in the Midwest to enforce clean air and clean water statutes. So what happens? The suits go after every deep pocket defendant, oil companies, fisheries, polluters, to enforce things that the state should do. The problem is that the incentives are different. The state wants clean air or clean water, but the plaintiffs in the private right of action and their counsel want fees and or damages. The state would just sue to get the mess cleaned up, and the Chaffetz amendment on loser pays, which was rejected yesterday, is an attempt to get at the problem by setting some pretty high barriers to entry. Because it failed, there are no speed bumps, except those provided under the federal private right of or the FRPCP, which we know have never enforced to stop reams of litigation. I think that we ought to think about this very carefully. I would urge support of the amendment. I don't think we should set up a specific private right of action in this area where there are no specific private rights of action in other areas. Finally, I would point out that while the U.S. Chamber of Commerce supports this legislation, they have been very strong about opposing private rights of action. So I would urge that this amendment be adopted. If we want to go this route, we ought to look at it in separate legislation, and I yield back the balance of my time.
Mr. Chairman.
The gentleman yields back his time. Recognize myself in opposition to the amendment. I do oppose the amendment. I'll yield to the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. This is a key provision of this bill. It is not correct that a private party can go into court and get a site taken down. This only applies to the follow the money approach, which we're hearing from those who don't like other aspects of the bill saying follow the money. This is what this allows private actors to do. And if you're just going to rely upon the Justice Department to do this, to say that only when the Justice Department goes into court can a court order a credit card company or an advertiser to not advertise on a foreign rogue website that is committing crimes, that is stealing individuals' property. If you're not going to allow this kind of civil relief, you are considerably damaging this bill. The gentleman's amendment eliminates the private right of action in the bill. This is an essential provision in the Act, and it's a necessary tool for rights holders against foreign rogue websites. If you want to talk about saving the government money, let people take their own actions to court if they think there's copyright infringement.
Only yield.
I will in a moment. The private injunctive relief in this Act is simply a follow-the-money approach. It promotes self-help by private parties, preserves government resources, and promotes due process safeguards for those accused of wrongdoing. Given the level of infringement online, eliminating private remedies would severely undercut enforcement actions. The bill includes several limitations on private relief. A site must first be deemed a rogue website by a court in order for a remedy to apply. This is a very high standard. The proceeding is against the rogue website, not against the payment processors or ad services who would incur no litigation expense and are provided with immunity from any suit or any liability arising from such court orders. The private right of action in H.R. 3261 has been carefully written to address the needs of right holders and technology companies. This bill represents a delicate balance. Making such a core change to the bill could turn the program into a paper tiger. And for those on both sides who agree that the follow-the-money approach is a good tool to use against foreign rogue websites, this would effectively dramatically nullify. You could only rely upon when the Attorney General wanted to go into court to require the credit card companies or others to not do business with these foreign rogue websites to get that kind of injunction. We've got to let private rights holders engage in that activity. Otherwise, we're not going to effectively address this problem. And someone asked me to yield.
I did, and I withdraw my request.
I thank you, gentlemen.
Your explanation is so good.
Actually, I've got the time, and I'll yield back my time. Are there other members who wish to be heard on this amendment? The gentleman from California, Mr. Issa.
Thank you, Mr. Chairman, and I thank you for continually trying your best to go Republican, Democrat, Republican, Democrat. I might suggest that you might as well go for and against. That'll save a lot of your for people the time, wasted time, because you run out of the against pretty quickly. Mr. Chairman, it's very clear we're going to lose here today. No, let me rephrase that. We're going to lose eventually, and we're going to lose in the worst possible way. We're going to lose without all the facts. We're going to lose without the process being open in the way that I would hope it will be in the new year. As to the specifics of this amendment, as you know, I'm not one of the attorneys here on the dais, so maybe I don't get it. Since we know you can't effectively sue a foreign entity that's outside the reach of our government, and since Mr. Goodlatte just said, and hopefully he's still hearing this, that, well, it's not about anybody but the foreign website, or the foreign property pirate, I'm going, okay, So this is about a private right of action in which we claim we're not going after the people with deep pockets here in the United States to get money damages, but in fact it is going to be about going after people, as far as I can tell, with deep pockets here in the U.S. to get money damages, because there's no pockets you can get to outside the U.S. You won't even get a successful service on somebody in Timbuktu. So I'm a little befuddled. I'm going to vote with Mr. Sensenbrenner, because if you can't explain, I'll yield when I'm done. If you can't explain the obvious, and Mr. Nadler, I know that you've got time and you'll explain it to me, and I look forward to hearing it. But, Mr. Chairman, I'd like to take advantage of this moment to ask unanimous consent that a letter from virtually everybody who helped create the Internet be placed in the record. This includes the CEO of and president of Inner Working Labs, the CEO of Apache Software, Glenn Reichart at Interconnection Point, et cetera, and I'll read a short part of it if it's accepted.
Without objection.
Okay. And the lead person is Vince Cerf, who everyone by now has figured out. He wrote IPv4 and participated in IPv6 and is probably the most knowledgeable person as to what will or won't work.
Al Gore. Gentleman yield.
I yield briefly.
Is Al Gore on that list?
He's conspicuous in his answer, his absence. Reclaiming my time, the letter starts off, and I know it's in the record, but we, the Understand, have played various parts in building the network called the Internet. We wrote and debugged the software. We defined the standards. Mr. Chairman, we're not in order.
The gentleman is correct. The committee will be in order. And the gentleman continues to be recognized.
I thank the chairman. We wrote and debugged the software. We defined the standards and protocols that talk over the network. Many of us invented parts of it. We're just as proud of the social and economic benefits of our project the Internet has brought to all of us. Last year, many of us wrote to you, I'm assuming this is the chairman, and your colleagues to warn about proposed COICA, copyright and censorship legislation. Today we're writing again to reiterate our concerns about SOPA and PIPA, derivatives of last year's bill that are under consideration in the House and Senate. In many respects, these proposals are worse than the ones we were alarmed to read just a year ago. If enacted, either of these bills will create an environment of tremendous fear and uncertainty for technological innovation and seriously harm the credibility of the United States in its role as a steward of key Internet infrastructure. Regardless of recent amendments to SOPA, both bills will risk fragmenting the Internet Global Domain Name System, the DNS, and have other technical consequences. In exchange for this, such legislation would engender censorship that would simultaneously be circumventing by deliberate infringers while harming innocent parties and their right and ability to communicate and express themselves online. And it goes on for quite a while about censorship, and I know my time is limited. Mr. Chairman, these people, more than we could put on 4 panels, 5 panels in this room, have serious concerns about both sides, the technical ability to do this, and the ability for it to be circumvented that we've talked about in the small minority for a number of days. And most importantly, Mr. Chairman, in closing, this is about a group that says, find another way. These are the very scientists that can help us find effective ways to do it on the committee if we'll only hear them in the first part of the year. And I yield back.
Gentleman's time has expired. Thank you, Mr. Issa. The question is on the amendment of Mr. Sensenbrenner. All in favor say aye.
Mr. Chairman.
Mr.
Chairman.
Okay. The gentlewoman from California, for what purpose does she seek recognition?
I'd move to strike the last word.
The gentlewoman is recognized for 5 minutes.
Mr. Chairman, I have great respect for the gentleman from Wisconsin, a former chairman of the committee. I do not share his overall animosity towards private rights of action in in law, but I do share his support for this amendment. And I'd like to say why. We had a spirited discussion last night about the lack of due process that is present in Section 103 that he seeks to strike. We made efforts to remedy that, and if this amendment is not adopted, I am confident there will be additional efforts to remedy that. But absent the opportunity to, as the gentleman said, put some road bumps in, have some kind of due process, I think I would be inclined to support his amendment. You know, to say that this is merely a payment remedy misses the point that if you are a small startup and without any due process, all of your revenue is eliminated, you're dead. You're done. It's the death sentence. And if you're a foreign infringing site, fine. We want the death sentence for you. But the problem is there's no due process in this provision that makes sure that's how it's limited. That has been further aggravated by the adoption of Mr. Goodlatte's amendment that allows for takedowns of entire sites instead of portions thereof. So although, as I say, I do not share the gentleman's hostility in every case to private causes of action, I do think the remedy that he has recommended in this case is a necessary one. I commend the gentleman for offering his amendment, and I would intend to vote aye with him. And with that, I would yield back my time.
Mr. Chairman,
Mr. Chairman. The gentleman from Utah, Mr. Chaffetz.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you. I stand in support of this amendment. I'd point to yesterday where I offered an amendment that would be essentially a loser pays provision. If there's a small victory for those of us that are concerned about this piece of legislation, the majority of the Republicans who voted on that voted in favor of that amendment. This is, as Mr. Sensenbrenner more eloquently and technically can explain, there needs to be a way to go through the due process without creating this flood of litigation that will certainly pour in by untold thousands and put some of our job innovators, our job creators, some of the best thing that's happening in this country job-wise, on the defensive, having to spend untold millions of dollars trying to protect themselves. And I'd be happy to yield to the gentleman from Wisconsin who can further expand upon that.
I thank the gentleman for yielding. This sets a precedent, and it's a precedent that will be expanded to other areas where we are talking about enforcement. Enforcement should be a law enforcement function in this area, and that's why the Justice Department should be given the right, and it does in this bill, to enforce the law. You know, we don't give people very many opportunities to sue everybody in the world because law enforcement doesn't do what they want them to do. We should not set this precedent here. I yield back.
Would the gentleman yield? Would the gentleman yield?
Be happy to yield to the gentleman from California.
I appreciate the gentleman yielding. Just 2 points. One, it wasn't a loser pays. It was only if those folks lose do they pay amendment, not if the other folks lose do they pay, all the issues that Mr. Johnson so eloquently brought out today. And secondly, we have a copyright law that's been in the law for a long time. It has the Attorney General allowed to bring criminal actions for criminal infringement. It has the Attorney General allowed to bring civil remedies, and it allows private rights of action for civil remedies. It allows adjunctive relief in certain situations. The notion that it's unprecedented to have private rights of action hand in hand with the law enforcement having the authority to engage in both criminal and civil actions is I don't know where that comes from.
Reclaiming my time.
Antitrust law, same kinds of
Reclaiming my time,
areas.
Mr. Chairman.
I yield.
Thank you. My time was.
Yes.
I'd like to yield to the gentlewoman from California.
Thank you. I just wanted to note something that, in support of Mr. Sensenbrenner's concern about seeking damages, there is a provision in the section where if there's an allegation that good faith efforts have not been made, there is an opportunity for an order to show cause, and the court has given opportunity to exercise its equitable authority, which would include not just specific performance, but also monetary awards. So I think that the point that Mr. Sensenbrenner has made is a valid one, and it's a little bit hidden in the section. But I did want to note that, and that his concerns is not entirely unfounded. And I would thank the gentleman from Utah for
Mr. Chairman. Mr. Chairman.
You're reclaiming my time. I'll yield back, Mr. Chairman.
Thank you, Mr. Chaffetz. The gentleman from New York, Mr. Nadler, is recognized.
Thank you, Mr. Chairman. Some parts of this legislation trouble me, but not this part, and I therefore will oppose the amendment. The whole point of the legislation is to stop foreign websites from infringing, from stealing private property, from stealing content. If this were, and I don't have any problem with private rights of action. I normally support private rights of action in the law, even where they don't exist. I wish there were more private rights of action. But here, if this were a domestic website, you in effect have a private right of action. It's called a normal infringement lawsuit. If your property is infringed, if you think that the domestic website is infringing your property, you sue them in a normal copyright infringement lawsuit. Because you're dealing with a foreign website here, you can't do that because you don't have jurisdiction. So if we pass this amendment, the only enforcement against foreign websites will be the Justice Department, and we know how that works. The Justice Department doesn't have enough manpower. They will be swamped, as they are in many areas, by thousands, millions of infringements which they can't go after. And if you don't allow a private right of action, there'll be very little enforcement. Now, you can argue about what types of enforcement there ought to be, but to say that only the Justice Department should enforce against foreign websites is to say that 90% of foreign infringing websites should be immune from enforcement as a practical matter. And that's just wrong. So I think that we ought to have a private right of action against foreign infringing websites, as you do in practice, if not in name, against domestic websites, and therefore I oppose the amendment.
Mr. Chairman.
I thank the gentleman from New York. The gentlewoman from California, Ms. Waters, recognized.
Mr. Chairman, I think it's important that we pay attention to what Mr. Sensenbrenner has said about striking private right of action. I'm a big defender of private right of action, and I'm a big defender because it has served us so very well as we have dealt with the environmental concerns that Mr. Sensenbrenner alluded to, the disabled, and civil rights concerns, dealing with discrimination. Now, we have a philosophical difference here, and Mr. Sensenbrenner talked about the trial lawyers and people just wanting to get money. I don't think that we should allow our philosophical differences to enter into this debate about whether or not there should be a private right of action for those whose properties have been stolen or who have been infringed on. And so while I have great respect for Mr. Sensenbrenner and his public policy capabilities, I think what he has allowed to creep into this is his basic philosophical difference about private right of action for citizens in areas that he disagrees with them on, such as the environment and perhaps the disabled and others. And so I would ask my colleagues not to allow that to influence your decision in this matter. I yield back the balance.
Thank you, Ms. Waters. I'd like to vote on this amendment, then we will recess until 1 o'clock, and I'll explain that in a minute. The question is on the Sensenbrenner Amendment. All in favor say aye. Aye. All opposed, no. No. Opinion of the Chair, the noes have it.
Roll call.
Roll call vote has been requested. The clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Coble? Mr. Gallagly? No. Mr. Gallagly votes no. Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Issa votes aye. Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Griffin votes no. Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Ross? Mr. Ross votes no. Ms. Adams? Mr. Quayle? Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Berman? Mr. Berman votes no. Mr. Nadler? Mr. Scott? Mr. Scott votes no. Mr. Watt? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes no. Ms. Chu? Mr. Deutsch? Ms. Sanchez? Ms. Sanchez votes aye. Mr. Polis?
Aye.
Mr. Polis votes aye.
Gentleman from Virginia, Mr. Goodlatte.
Mr. Goodlatte votes no.
The gentleman from New York, Mr. Nadler. Oh, the...
Mr. Nadler votes no.
The gentleman from Texas, Mr. Gomert.
Mr.
Gentleman from Texas,
Mr. Gomert
Mr. Poe.
votes no. Mr. Poe votes no.
And other members wish to be recorded. If not, the clerk will report.
Mr. Chairman, 8 members voted aye, 20 members voted nay.
Majority having voted against the amendment is not agreed to. We have a series of votes ongoing that will last till about noon. From noon until 1 o'clock, there is a Democratic caucus. So we are going to recess until 1 o'clock promptly, and we will continue the markup at that point. We stand in recess.